California still has the death penalty. But here's the part most people miss. Just because prosecutors can seek death doesn't mean they ever will. Today, I'm answering one narrow question. In the Nick Reiner case, is the death penalty realistically on the table or only legally available on paper? Here's the factual frame. Nick Reiner is charged with 2 counts of first-degree murder in Los Angeles County. The case is early. Many facts are not public. No penalty decision has been announced. Prosecutors allege premeditated murder. That matters because first-degree murder opens the door to what we call special circumstances, and with them, exposure to life without parole or the death penalty. What remains unclear is whether this was a planned act or a moment of emotional collapse inside the home. That uncertainty drives everything that followed. If you're arguing death is legally possible, here's the path forward. California law still authorizes the death penalty, and a jury can still impose it. First-degree murder with special circumstances is the gateway. In principle, prosecutors could seek death here, particularly if they believe the evidence supports premeditation and aggravating factor. And the Los Angeles District Attorney's Office has signaled formally that death remains available in the rarest cases. So legally, the option exists, but capital cases aren't decided on statute alone. Now the other side, and this is where reality intrudes. First, the defense will challenge premeditation. They may argue heat of passion, emotional disturbance, or a sudden triggering event rather than any cold planning. That distinction matters because death penalty cases turn on the narrative. Second, California has not even carried out an execution since 2006. There's a standing gubernatorial moratorium, and in Los Angeles County, death remains the exception, not routine. Third, and most important, mitigation. Public reporting suggests serious mitigating issues. These include long-standing mental health concerns and years of treatment and rehabilitation. Now, I'm not diagnosing anyone. I'm not deciding facts. But under California law, severe mental illness and treatment history are classic mitigating factors when prosecutors decide whether death is on the table. These mitigators don't excuse conduct, but they often weigh heavily against the death penalty at all. So let's cross-examine the real decision that prosecutors face. The question isn't, can the statute support death? The real questions are, what actually happened inside that house? Can premeditation be proven beyond a reasonable doubt? And how will a jury respond? In modern capital litigation, mitigating issues often overwhelm aggravation when the full story emerges. That's the quiet reality prosecutors face. Now here's the legal reality in plain English. California's death penalty still exists, but executions are paused by executive order. As a result, death functions less like an outcome and more like leverage. Prosecutors must choose between life without parole or pursuing death through years of litigation, penalty phases, and appeal. Death isn't automatic. It's a decision. Now here's how I would rule on the death penalty question in this case without deciding guilt. Is the death penalty legally available? Yes. However, is it realistically likely to be sought by prosecutors? Probably not. Given the unresolved fact, the narrative uncertainty, and the mitigation that's already visible, this case does not resemble the type where death is typically pursued in California. Death penalty cases in California are reserved for those with clear facts, overwhelming aggravation, and minimal mitigation. This case, at least how we understand it now, does not clearly fit that mold. The death penalty still exists in California law. But in real court, what matters isn't what the statute allows. It's what prosecutors can prove and what juries will accept. And, in the end, what the system can sustain. That's the difference between accusation and outcome. Thanks for watching. If you want real legal analysis without the noise, subscribe. And for deeper coverage, visit CrimesDigest.com. And always remember, the truth matters, and so does reasonable doubt. See you in the next case.